You are unmuted.
Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near. Give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Jurors remain standing. All other parties may be seated.
Jurors, can I have each of you raise your right hand? I just have to wait 1 second, jurors. So you can put your hands down for a second. There's just one more person coming in. You can put your hands down for a second. Great. Could I have all the jurors now raise your right hands? Do you solemnly swear to make true answers to such questions as should be put forth to you by the court, so help you God? Thank you. You can have a seat. May I call the case, Your Honor?
Please.
Your Honor, this is docket number 2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Attorney David Yannetti for Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George for Ms. Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, good morning, jurors again. I appreciate your patience, and we did get you over here within the hour. My name is Beverly Cannoni. I'm a judge of this court, and I want to give you some idea on how the day is going to go for you and why we're here. So I do want to express to you that jury service is certainly one of the most important civic duties we have. So we all appreciate the fact that you're here today, ready, willing, and able to serve as jurors if called upon to do so. Now, you've heard that this is a criminal case. It's the case of Commonwealth versus Reed. The Commonwealth alleges that at approximately 6 a.m. on the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department, transported to the Good Samaritan Medical Center, where he was later pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. The defendant is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death. I will describe in detail at the end of this case, when I teach you the law, the elements of the crimes that she's charged with. But briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder, and that murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in the courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, the rule of law will be upheld. Now, in order to determine your eligibility to serve on this case, I'm going to ask questions to you all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you're not selected for this jury service on this case, you should not take it personally. Please don't think that somehow we feel you're not a fair person. It's not a reflection on you at all. You will be directed back to the jury room and probably let go for the day. In a few minutes, I will pose a number of questions to you as a group. You have taken an oath that requires you to truthfully answer these questions and all questions posed to you. If your answer is yes to any of those questions, I'll ask you to raise your hand and hold up your juror card in the air with the numbers facing out. So you don't need to take your cards out now. I'll tell you when you can take them out. But it's important that you hold your car up long enough. You'll see that the court officers will call out your numbers and we record them. The fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that the lawyers and I must discuss with you. If you find a question posed to the group overly intrusive, you may elect to answer that question at sidebar. I will have additional questions for you which relate to issues that will be raised in this case and are designed to give us more information regarding your ability to serve as a fair and impartial juror. And the lawyers are permitted to ask you questions for the same reasons. This is not a test. There is no right or wrong answer. We simply are looking for your best answer and your most honest answer. Now I'm going to ask the lawyers to stand and simply introduce themselves to you, and counsel for the defendant to introduce the defendant, please.
Yeah.
Yes.
Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. I'd like to also introduce you to my colleagues.
Good morning, my name is Laura McLaughlin. I'm an assistant district attorney and I represent the communities in Norfolk County. Good morning.
Good morning, my name is Adam Lally. I'm also Assistant District Attorney with the Norfolk County District Attorney's Office. I just want to thank you all for your time and attention and being here today.
Mr. Jackson?
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Alan Jackson, and I have the privilege and honor to represent Karen Reed, who's standing to my right.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little and I also have the honor of representing Ms. Reed.
Good morning, ladies and gentlemen. My name is Robert Alessi, and I also have the privilege and the honor of representing Ms. Reed.
Good morning, ladies and gentlemen. My name is David Binetti. I'm an attorney with offices in Boston and right here in Dedham, and it is truly my pleasure to represent Karen Reed.
Good morning, ladies and gentlemen of the jury. My name is Victoria George and I also have the privilege of representing Ms. Reed. Good morning, I'm Karen Reed. Thank you for being here.
All right. Thank you all very much. Jurors, I'm going to read you a witness list, and it's a long witness list. It doesn't mean that all of these people will be called as witnesses. Some, we have their names there just to see if you're familiar with them, because if they don't testify, you may hear about them anyway. So I ask that you be patient and you listen carefully to this list, because at the end of this and a few more things that I say to you, I will be asking you whether you know any of these folks. So it's in alphabetical order, but it's alphabetical by first name. So, Aidan Kearney from Jefferson, Massachusetts. Isaac Wolf, who is a physician from South Miami, Florida. Alfred Lopalato from Canton. Allison McCabe, Canton. Andre Porto from the Massachusetts State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler, who's a PhD from Pittsburgh, Pennsylvania. Angela Malvone from Canton. Annie Chung from Canton. Anthony Flamati from Canton Fire Department. Ashley Bell from Canton. Ashley Valaire from the Mass State Police Crime Lab. Brian Albert, Norwood. Brian Albert Jr., Boston. Brian Higgins, Sandwich, Mass. Brian Loughran, Canton. Brian Wanless, who is retired from the Canton Police Department. Bridget Meehan, who's a keeper of the records from Canton. Caitlin Albert from Easton. Charles Ray, who's a lieutenant in the Canton Police Department. Helena Rafferty, who is the chief of police in the Canton Police Department. Chris Van E., who's a PhD from Novi, Michigan. Christina Hanley from the Mass State Police. Christopher Albert from Canton. Christopher Curran from Canton. Colleen Crawford from the Norfolk District Attorney's Office. Colin Albert from Canton. Courtney Proctor from Canton. Kurt Roberts from Canton. Daniel Whitley from the Canton Fire Department. Daniel Wolf, who's a PhD from Penns Park, Pennsylvania. Derek Ellington, who's from Wake Forest, North Carolina. Dr. Marie Russell, Los Angeles. Dr. Elizabeth Loposada, who is from Providence, Rhode Island. Elizabeth Proctor, Canton. Eric Hanlon, Canton. Erin Beatty, Canton. Erin O'Keefe from West Bridgewater. Francis Walsh from the Canton Fire Department. Garrett Wing from Green Cove Springs, Florida, Gary Fowler from Brockton, Gregory Woodbury from the Canton Fire Department, Gretchen Voss from Boston, Hannah Knowles, the State Police Crime Lab, Heather Maxon from Walpole, Erabito Hernandez from the Boston Police Department, Holly Price from Mountain View, California, Ian Whiffen, Vienna, Virginia, Dr. Irene Scorti Bello, who is from the Chief Medical Examiner's Office here in Massachusetts, James Crosby, who is a PhD from Jacksonville, Florida, Jason Becker, Canton Fire Department, Jean DeMoulis, Canton, Jennifer McCabe, Canton, Jessica Hyde from Bridgeport, New York, John O'Keefe Sr. from Braintree, Judson Welcher, who's a PhD from a company called Aperture LLC, Julie Albert from Canton, Julie Nagel from Canton, Justin Rice, who is a physician from South Weymouth. There are 2 juveniles from Canton. One of the juveniles' initials are KF and the other PF. Caitlin Boudreau from Raynham, Karina Kolakithas from Canton, Katie Camerano from Canton, Katie McLaughlin from the Canton Fire Department, Keeper of the Records for Ring from Hawthorne, California, Kerry Curran from Canton, Kerry Roberts, Canton, Kevin Albert, Canton, Kevin O'Hara from the Mass State Police, Lance Mello from the Mass State Police Crime Lab, Laura Sullivan from Pembroke, Laurie Cahill from Worcester, Leslie Pearlstein from Canton, Lieutenant Michael Lank from the Canton Police Department, Louis Jutras from Canton, Lieutenant Brian Tully from the Mass State Police, Lieutenant John Fanning, Mass State Police, Lieutenant Paul Gallagher, Canton Police Department, Maggie Gaffney from Bonita Springs, Florida, Mark Lopalato from Canton, Margaret O'Keefe, Canton, Marietta Sullivan from Pembroke, Mary Souza from Dighton, Matthew Amory from Canton, Matthew DeSogra, who is from Charlotte, North Carolina, Matthew Erickson from Grosse Pointe Farms, Michigan, Matthew Kelly from the Canton Fire Department, Matthew Kelsch from the FBI, Matthew McCabe from Canton, Maureen Harnett from the Mass State Police Crime Lab, Megan Mariani from New York, New York, Michael Camerano from Canton, Michael Easter from Los Angeles, Michael Trotter from the Canton Public Works Department, Michael Wagner from Foxborough, Mike Maroli from Bridgewater, Mike Rushworth from Thompson Station, Tennessee, Natalie Wyweek Berschneider from San Marino, California, Nathan Reed from Raynham, Nicholas Bradford from Lorton, Virginia, Nicholas Curran from West Roxbury, Nicholas Kolakithas from Canton, Nicole Albert from Canton, Norfolk District Attorney Mike Morrissey, Officer Kelly Deaver from the Boston Police Department, Officer Nicholas Barrows from the Dighton Police Department, Patrick Haggerty from Somerset, Mass, Paul Wachowski from Melrose, Mass, Paul O'Keefe from Canton, Rebecca Bazin from Canton, Rebecca Treyers from Norfolk, Dr. Renee Stonebridge, who is also from the Office of the Chief Medical Examiner in Boston, Richard Green from St. Pete Beach, Richard Donatino from Canton, Robert Gilman from Hull, Ryan Nagel from Canton, Sarah Levinson, Canton, Sergeant Brian Gallerini from the Needham Police Department, Sergeant Sean Good from the Canton Police Department, Sergeant Paul DiGiambattista from the Canton Police Department, Sergeant Yuri Buchanan from the Massachusetts State Police, Shannon Burgess from South Lake, Texas, Cheryl Waugh from Canton, Sophie Herzan from the State Police Crime Lab, Stephanie Devlin from the State Police, Massachusetts State Police Crime Lab, Stephen Mullaney, the Canton Police Department, Steve Nelson from the Norfolk DA's office, Stephen Bernstein, who is a keeper of the records from Stoughton, Stephen Ridge from the Boston Police Department, Stephen Seraph, Canton Police Department, Stephen Scanlon from West Roxbury, Terry Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty, Canton, Thomas Kelleher, Canton, Thomas Martin, Weymouth, Timothy Nuttall from the Canton Fire Department, Tristan Morris from Easton, Mass, The following are Massachusetts State Troopers. Trooper Connor Keefe, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Kostkowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, and Trooper Zachary Clark. Wendell Robery from Canton and William Reed from North Dayton. Those are the witnesses who may be called to testify before you. So, as you can see, this is going to be a long trial. We've already begun the empanelment process. It's going very quickly. The lawyers tell me that they expect that once we start with the evidence, it will take between 6 and 8 weeks for the case to be tried, for the evidence to be presented to you. That's a good faith estimate. It's the best we can tell you at this point. Every single day, if you're a seated juror, I will tell you at the end of the day whether we are on schedule, whether we're ahead of schedule or behind schedule. And I have not had to tell jurors that we are behind schedule. And I intend not to have to tell jurors that we're behind schedule. So it's a good faith estimate, the best we can do, but that's what we expect will happen. Once we start, it's expected that we will go full days from 9 o'clock to 4 o'clock. We'll start at 9. The jurors will have a break somewhere around 11 for 15 or 20 minutes. Lunch and break is usually around 1 o'clock. In an effort to take full advantage of your time, we will bring lunch in to you. Rather than asking you to walk down to Dedham Center and get something, that process also takes a lot of time, and we figure while we're here, we would like to take full advantage of the day. So lunch will be brought into you. It may be that we have a half-hour lunch, it may be a little bit longer, but there will be a break for lunch and it will be provided to you. We will go until about 4 o'clock in the afternoon. There are a few days in the schedule that we won't be in session, and there are a few more half days, and we'll let you know the schedule for people who are seated. Now, it might help if I give you a preview now about some basic law that applies to criminal cases like this. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a brief summary of some very important constitutional principles that will guide this trial. First, and most basically, Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a person of a crime and bringing that person to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt and to a moral certainty. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove his or her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant can sit back in the chair and say to the Commonwealth, you accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word. A defendant's decision whether to testify or not has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it at all in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. So that brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used, probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if After you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in the case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair. I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making your mind up before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law, instead of upon unsupported assumptions. Fourth, as you listen to testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of on any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing. Perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So don't worry if you didn't catch everything I said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it to you. So, for jury selection, it is important to know if any of you might have some doubts whether you can accept and follow these legal rules. Now you can take out those cards. So in a few minutes, I'm going to ask you a series of questions, and if your answer is yes, please raise your hand and let the court officer read the number off. But before we begin, I understand that sometimes jurors don't fill out the confidential questionnaires completely. Sometimes we're in a hurry to get them back in, or sometimes we might think that our situation doesn't apply to the question that's being asked, or sometimes we simply don't remember. So if there are any things missing from the form, I will ask you, or the clerk will ask you, like age. Sometimes people don't put down whether they were jurors in a case, or witnesses in a case, or a defendant in a case, or a plaintiff in a case. If there's anything that you forget and you realize now before you come up here, anything you've forgotten on the form, please just let us know. But we just need to keep records, so thank you for your patience with that. All right. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I called?
Juror numbers 525, 495, 512.
Thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or the Norfolk County District Attorney's Office?
Juror number 525, juror number 531.
Juror number 533.
Okay, thank you. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. Please raise your hand if you have seen, heard, or talked about this case.
Juror numbers 492, 469, 478, 525, 472, 471, 474, 488, 517, 507, 476, 485, 545, 479, 535, 512, 482, 513, 495, 477, 530, 502, 526, 528, 490, 509, 500, 547, 467.
Juror number 463, 523, 514, 510, 515, 537, 531. Number 522, 486, 484, 464, 506, 529, 481, 542, 533, 494.
Juror number 460. Juror number 536. Juror number 498. Juror number 508. Juror number 524. Juror number 505. Juror number 527. Juror number 532. Juror number 511. Juror number 468. Juror number 534. Juror number 470. Juror number 466. Juror number 546. Juror number 521. Juror number 516. Juror number 461. Juror number 544. Juror number 465. And juror number 541.
Okay, thank you very much. Could you please raise your hand if you've expressed or formed any opinion with respect to this case?
Juror number 492, 469, 478, 525, 472, 474, 517, 507, 476, 485, 545, 530, 495, 513, 488,
Okay, thank you very much. Are you aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? And if you are, please raise your hand.
Juror numbers 512, 472, 517,
528, 500, 514, 537, 531, 542,
536, 470, and 546.
Okay, thank you very much. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict?
Juror number 499, 474, 513.
juror number 522, juror number 484.
Thank you. Would any of you have any difficulty following these very important constitutional principles that I outlined to you earlier? That the burden of proof rests entirely with the Commonwealth, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty, and that the defendant has no burden to do anything. She can just simply sit in that chair. She doesn't have to present any evidence. She certainly doesn't have to testify, and her lawyers don't even have to say a word. Does anyone have any difficulty with those important principles of law? If you do, please raise your hand. I see no affirmative responses. I can tell you folks that after every trial, I go in and I speak to the jurors. And though many of them were reluctant or certainly not happy about having jury duty, after they have heard the trial and deliberated and reached a verdict, every single jury, there's been several people who not only tell me that it was an interesting experience, but that it was also a rewarding experience. I do, however, realize that for some of you folks, serving on this jury would be an undue hardship. And let me tell you what I mean about that. Because certainly every civic duty we have causes us some hardship or inconvenience. An undue hardship is something much greater than that. It's usually if you're a student or if you've got airline tickets or surgery scheduled during the duration of this trial. But I will hear from people who believe that they have an undue hardship. So if you think you are among that group, please raise your hand.
Juror numbers 492, 525, 474, 517, 507, 476, 485, 469, 545, 478, 530, 495, 513, 482, 535.
Juror number 526, 547, 467, 463, 514, 510, 537, 487, 531, 486, 522, 494, 533, 529, 464, 484.
Juror number 460, juror number 536, juror number 508, juror number 524, juror number 532, juror number 516, juror number 466, juror number 470, juror number 461, juror number 491, juror number 544, juror number 465, and juror number 541.
All right. Thank you very much. So I am going to leave the bench in a minute to give you a chance to fill out those supplemental questionnaires. I ask that you not talk to anybody about either the questionnaires, your answers to the questionnaires, jury service in general, or jury service in this case in particular. So I'd ask you not to discuss anything with anybody around you, okay? And we appreciate your patience, and I'll leave you to fill out those forms.
All right, please.
May be seated, close your recess. Just a reminder, everyone, please turn left hold the box, so left hold the door. Goodbye.
Oh, okay, great.